Joining us now is the Attorney General, Mr. Phillip. So good morning, Mr. Phillip. How are you doing?
Morning, and thanks for having me.
All right. Thank you for coming. Yeah. All right.
First of all, what is are there any latest updates with the airport authority and the matters that is arising down there?
Well, as you would know, the airport authorities are separate and distinct entities from the government, so they would be better able to speak, I'm sure, at an appropriate time as to where they are and what they're doing. From the government's point of view, however, and I'm sure that is in relation to the overall Exim Bank claim against the government. What has happened, as I'm sure the nation already knows, restraint notice was served on various entities plying the trade in Grenada, first on the cruise lines, later on the airlines, which, in light of your particular question, we will focus on. In light of the restraint order, it orders the airline to refrain from paying to Grenada or the instrumentalities of Grenada, that is some of the language used, any monies due and owing to them. In compliance of that order, these airlines have withheld the money and in 2 instances elected to pay the money into an escrow account. The latest development we have is that the bank, through its attorneys, have filed further interrogatories asking for specific information as to monies due and owing, how are the payments made, and so on. Those we have forwarded to the airport authorities and the other statutory bodies, and we are awaiting their response. I know the relevant statutory bodies were seeking to retain counsel to deal with the matter in terms of the restraint, and they would be, as I said, better able to speak at a time when I'm sure it's appropriate, what they have done and what is the state of that development. But from a government point of view, we certainly think that some action needs to be taken by the statutory bodies, because our view, the fact that they are independent bodies, their assets or funds are not automatically liable to forfeiture or anything else to satisfy a debt of central government. In law, there are certain procedures that may be used to make that happen, but in our view, that certainly was not followed, and we don't think it's applicable in this situation.
Okay. Can you tell us the effect that this type of thing would have, like for instance, the port authority paying into that? What kind of effect it would have on us?
Well, as with anything else, any entity or even individuals, if your regular source of income is cut out, it puts you in difficulty.
Right.
I mean, as individuals, if our income is not paid, we don't get our salaries, after a month or two we'll start to have difficulties, except we have other sources. So certainly in the area of the statutory bodies, it will mean that they're not getting their regular, or at least a portion of their regular source of income. And so if they have reserves, they would have to start tapping into it.
Right.
And with time, one would expect that those reserves itself will be depleted. It is no secret that our statutory bodies in Grenada are very lean in terms of none of them are really profit-making entities, and so I'm sure it's posing quite a bit of difficulty for them. Hence the reason I think they saw it necessary to make that application or retain counsel to do what they, to have the order vacated.
Right. Which brings me to ask, how long do you think this will carry on for?
Well, how long it would carry on for? I mean, the underlying issue in all of this is the debt owed by the government of Grenada to the Exim Bank of Taiwan. The only true response, or the only complete response to that issue is the satisfaction of that debt, meaning the government paying that debt out. I phrase it that way to say to you, except the government can raise the funds to pay out that debt, there is the potential of that issue continuing. And that's the stark reality. The judgment debt, as it stands, is in the range of $30 million US. Again, it's no secret. What is the financial and economic stance of Grenada or any other country in Grenada's bracket or category nowadays? So it's not, $30 million is not readily available that Grenada could simply cut a check and pay to the Exim Bank of Taiwan. That would involve some negotiations, that would involve the possibility of raising the monies through loan or otherwise. And I'm sure you would appreciate one cannot truly set a timeline to those processes. The government do appreciate the urgency of the matter. The government do appreciate the ongoing impact it's having on the nation generally, and in particular the statutory bodies at this point. And notwithstanding whatever action the statutory bodies may choose to take as they see fit, the government is making every effort to raise those monies or be in a position to satisfy the debt, because that is the only complete response. Everything else may simply ameliorate, may simply put off for a time. But once there is a debt, there is always the potential of them, that is the bank, pursuing the matter in the ways they have been pursuing it.
Will the airport close down?
I think I could safely say no. I mean, the reality is, in any country where you have key institutions, those institutions simply have to do whatever it takes to remain alive. Again, look at it in our own private lives. There are certain things in our lives, no matter what come our way, we have to maintain, we have to keep doing. And I would say the airport, as with other institutions in the state, is one such institution. A comparable institution, I would say, probably is our hospital or our health. Whatever happens, we have to keep our health institutions going. And in the same vein, I think whatever else may happen, we have to keep the airport going. So I think one could categorically say, no, the airport would not close.
So is there any plans for the government to assist the airport authority?
Well, again, as indicated, the airport authority is a separate, distinct entity. So the airport authority does its business. The government have a role to play in terms of policy and the like. Naturally, ultimately, the airport is one of the state's probably largest piece of infrastructure or so. So whatever the government can do to facilitate, to make things happen, it certainly will. But it's really a function of the airport and its governing body, the board and so on. So yes, the government will not sit by and not facilitate or do what it can to assist, but it's not a government issue. And don't misunderstand this to mean that government is passing the buck or saying, well, it's your thing, do it on your own. That is clearly not the case. But in situation like this, when corporate entities are established, there is that distinct role to be played. And so the airport and all the other statutory bodies, through their governing structure, will do what they need to do. But as I say, the government will do all in its power to facilitate and ensure that they continue to be viable and open, functioning institutions.
Okay.
All right. Talk to us about something a little different. The FIU and their proposed terrorism bill.
Trying to take me off of that. FIU and terrorism. Much talked about subjects.
Right.
Necessary, nonetheless. It's no secret the world in which we now live. The FIU, it's an institution that has been established since in the early 20s, 2003 thereabout. Yes, I know much talk in a recent parliamentary debate was made about there is an act, there is an FIU in existence. That may be so, but clearly the present structure of the FIU is inadequate. In our view, it leaves it open for greater challenges, for greater objections than the proposed structure. And again, there is certain functions that the FIU is required to perform, which under its current construct, it's not possible. A lot of these things are recommended by the Caribbean Financial Action Task Force, which is an associate body of the Financial Action Task Force, which is a more international, well, the international body that regulates this issue. And it's part of the commitments we have signed on to. The reality, many of these commitments is nothing you can shock or decide you're not doing, because it have other very serious implications for the country. So yes, we are passing a new FIU bill, which we hope will give it an enhanced governance structure. I mean, one critical area we hope to address and was talked about, the FIU, under its present dispensation, I don't even know what it is. On the one hand, it seems to be setting up a statutory body in terms of the appointment of the director and so on. But on the other hand, it didn't give it the full complementarities that a statutory body would have. It says that the director would be appointed by the Minister of National Security, and he performs certain functions. It speaks of police officers and customs officers being seconded to the FIU. But one of the very difficult situations we have is when they're seconded, who do they respond to? Who do they answer to? A police officer seconded to the FIU, do he answer, or does he answer to the Commissioner of Police? Or does he answer to the director of the FIU, who is in charge of the FIU? And they're not easy questions to answer. I mean, and we have seen the difficulty in the past, where certain things are required by the FIU officers, and the police give certain directives, or when they need to do certain things, they need to get permission from the commissioner to do it, either to travel or otherwise. Under the proposed construct, we say the director would be appointed by the Governor General on the recommendation of the Public Service Commission. So we have removed it completely from political influence in terms of the appointment and tenure. And secondly, we say the officers of the FIU will be officers of the FIU. They may have the training and competence of police officers or customs, but they're officers of the FIU, so they're subject to the direction of control of the director. And it makes much better for management, for the undertaking of the work and so on. And these are just a few I highlight in terms of the changes, which we saw as necessary changes. Terrorism, quickly. Again, we had a terrorism bill. Yes, a terrorism act, passed again in 2003 or thereabout, because as you would have realized, the things happen in cycle. Around 2003 thereabout, that was when Grenada got over its first review, and certain recommendations were made, so a number of these pieces of legislation were passed. We had our last review in 2008. Again, we were graded not compliant, in some instance partially or non-compliant. And it's not required that we upgrade these pieces of legislation to meet the change in circumstance. I mean, the reality of the world, even in 2000, 2001, when we were subject to our first review, and the world today is different. And so you have to meet these changing standards, and that is the reason for the FIU. First of all, it was the view that the act that was passed didn't meet completely meet the standards then. That's why we were not given a fully compliant report. And the standards have certainly changed. Even now, as we speak, the FATF is in the process of reviewing the standards, which we anticipate they're going to confirm later this month. And so by March, there will be new standards we need to comply with. Not revolutionary new, but nevertheless new. And so we'll be required to change our legislation to be compliant once again.
The terrorism bill that was withdrawn and redrafted, dealing with that. I'm speaking to you now as a lawyer, and the capacity that you have. Are you satisfied with how the matter was addressed?
You mean the drafts that were presented?
The redraft.
Yes, I am. Some issue was raised. On a reflection, we think they had merits. One critical issue that was raised was the process by which one may obtain interception order or intercept one communication. It then had for the minister to make the order. And I would tell you, not wishing to defend that position, the reality of this kind of provisions is that time is always of the essence. You don't want that a situation arise where there is a potential terrorist involvement and you have to go file an application, find a judge. Yes, I accept. The law makes provisions for urgent application, even where you may attend at a judge's home and get an order. So yes, there are those provisions. But even so, they're not always the easiest thing to happen. And as such, you have, that is the object of this type of provisions. On reflection, however, we felt and we appreciate that it's always a balancing act. The need for speed and meeting your objectives and the protection of persons' fundamental rights and of privacy and otherwise. And as such, we felt, notwithstanding the possible delay, it was sufficiently important to have it reside with a High Court judge. So that change was made. Another one that was highly debated was the issue of the order for a search warrant or to stop and search. Again, it made provision that if need be, one may get a justice of the peace to issue such such warrant, and then the person will go on. It was felt that the significant implication of a such warrant, meaning one, you enter into one premises and again evading the privacy and otherwise, it warranted someone with greater judicial power than a justice of the peace to do it. But again, justice of the peace was used from a practical point of view. Take Carrick or Pitty-Matnick, for example. We don't have resident judge, even resident magistrates. So an officer in Carrick wishing to do certain things will have to communicate to an officer in Grenada, either send the particulars where they would then have to attend before a magistrate here or a judge. Again, we're not saying it's an impossible thing, but it obviously would be a little more time-consuming than if you could attend at a justice of the peace. Once again, in balancing the rights, we felt it was sufficiently important. So we have changed that a magistrate can do. It has certain limitations, but in balancing what one needs to achieve and the protection of one's right, one have to take these things into consideration.
Are you satisfied that people's civil liberties are not being compromised?
Oh, clearly. You know, the issue of one's civil liberties is this. One guard against possibility of abuses by putting certain checks and balances in legislation or having them available. The reality is the only true check to that is that if and when it's done, that there are procedures by which one can vindicate your right. I say that because if you have a rogue officer or a rogue, whoever is administering this law, irrespective as to what check and balance you put there, if he wants to do something rogue, he'll do it. So you could put the greatest constraint in the legislation, but if for whatever motivation a person wishes to violate it, they'll violate it. As we have seen. Every offense that has been committed in Grenada or anywhere else, the reason it's of offense is because it's done contrary to stipulations contained in the law. But people do it. What is the check is that there is a system by which the persons whose right is affected can be vindicated. And that was always there, even under the original draft. It was always available to citizens to approach the court and say, my rights have been infringed, I have been prejudiced in whatever way, and address it. Again, as I mentioned before, we felt that there must be some level of balance, and that's why we thought it useful and prudent to make the changes or some of the changes that was recommended. But there is no doubt in my mind that there was always protection of persons' civil liberty, and there shall always be. The Constitution gives that protection. And no matter what level of law we pass, it cannot be contrary to the Constitution. And if by mistake, and I say mistake because that's the only so it can be, it happens to be contrary to the Constitution, it is open to anyone, and not just citizens, anyone within the boundaries and jurisdiction of Grenada to apply to the court and say my rights has been violated.
And what about ALBA? What is Grenada's position on ALBA?
Grenada's position on ALBA is not a legal issue, so I would not venture to speak there. I suppose it would have to be a policy decision. We have heard some comments by persons, Prime Minister and otherwise. I cannot say that Grenada has taken a position on it. I don't know them to have taken it. We're not a member of ALBA at present, and it is not for me to say that we will or will never be a member of ALBA. I don't know. As far as I know, the government or the state has not taken a position on it.
Right. The issue is well, not us being a part of ALBA, but with the decision that was taken with
The Falkland Islands.
the Falkland Islands, with the is it Argentina?
Yeah.
You know, going with them over the UK, would that have any effect on us, on our relationship with the UK?
Well, again, as I indicated, we have, as far as I understand, if I understand your question correctly, my reading from the press is that the ALBA nations have taken a position that they will support Argentina in terms of the blockade and otherwise,
Right.
in respect of ships and otherwise dealing with the Falkland Islands. The fact that Grenada is not a member of ALBA, that does not apply to Grenada. I have noted in the press, however, that even CARICOM members of ALBA have not maintained that position. Truth or otherwise, I don't know, but that's what the press is saying, that although we have, for example, Antigua, St. Vincent, and Dominica being members of ALBA, their relation with the Falklands is not that of ALBA.
Okay.
Whatever I may say, that's my understanding from the press. As it relates to Grenada, Grenada has always supported the people of the Falkland Islands for self-determination. And the recent visit of two members of the Falklands House of Representatives of Parliament was in Grenada, and certainly, as far as I know, the relationship with Grenada and the Falkland Islands have not changed. Whatever pronouncement may or may not have been made by the ALBA nations.
Okay.
We have a question from one of our viewers via BBM. They want to know, how is the government going to proceed on the Hamilton Grand Beach matter? Is there plans to pay Hamilton the $40 million in question?
What the government has done with respect to the Hamilton Grand Beach, however one chooses to call it, is that, and probably I should backtrack. What had happened in the past, or what the situation as it was, is that the government of Grenada had sold the freehold reversion to that property to the Hamiltons, a company owned by the Hamiltons. In recent times, what the government have sought to do is to acquire that freehold reversion by compulsory acquisition. The reality is there had been ongoing negotiation with the Hamiltons with the possibility of a voluntary return of the property. It was the view of the government that wasn't working out as it had hoped, and it needed to take further action. So what it has done, it has compulsory acquired the freehold reversion. Yes, the law provides that if one compulsory acquire, or the government may compulsory acquire property of a person for a public purpose, but it warrants compensation. As far as I know, the compensation for the freehold reversion is not 40 million. So I don't know the government is obliged or responsible to pay to the Hamilton or anyone else $40 million. There is a process under the Compulsory Acquisition or Land Acquisition Act which determines what is the due compensation for property that is acquired. The government certainly intends to abide by those provisions, and that will determine what the compensation, if any, that is due to the Hamiltons, or the company rather, in respect of that. What I can say to you very categorically, we don't know it to be valued at $40 million.
The compensation or the property?
Well, compensation is the property, is for the property.
Okay.
And that's why I made a clear distinction when I started out. The property of which we now speak is the freehold reversion. And probably I should clarify that. Under real property law, when there is a lease on a property, in effect, the interest in that property is split. Part of it goes to the tenant who holds the lease, and a part resides with the original owner who gave that tenant the lease. The tenant, their interest is called a leasehold interest, and the interest that resides with the original owner is called the freehold reversion. Back in 2008, what the government of Grenada sold was the freehold reversion because Mr. Nicholas and his company then held a lease over the property. That freehold reversion is what was sold to the Hamilton company. It is that freehold reversion that has recently been acquired. In the scheme of things, without getting into specific figures, the reversion is always significantly less in value. And well, I should backtrack a bit. Depending on the duration of the lease that the person have, it would affect the value of a reversion.
Okay.
Because what the leasehold in effect does is that it gives you the property to use it as you please, and the freehold reversion has a interest in it, but they don't have the practical use of the property. Under the current dispensation, the lease which Eastern Nicholas has was originally a 99 years lease with an option to renew. That lease was given in the late 90s, 1998, thereabout. So there is in excess of 60, 70 years on that lease still to subsist. So even the property had remained with the Hamiltons, under normal operation of the lease, they would not have had use of it for the next 60, probably 70, 80 years.
Okay.
I said normal operation because other things may have intervened to cause them to do other things, but under normal operations, they would not have had it. And the compensation that will become payable, if and when we get to that, is compensation for having an interest in property that you could get the practical use of 60 years from now, 80 years from now.
Okay.
That is what they was holding on to. That is what has been reacquired by the government of Grenada.
Okay. I know you said that the value of that is not that great because of that lease on the property.
It's usually always much less than the overall value of the property. And the longer the lease, the less the value of that, because the longer it would take you to have practical use of it.
From what I understand, though, they've actually paid taxes based on it being $40 million. Do you know if that's true? And if it is, wouldn't that suggest that it is valued at $40 million?
I cannot speak specifically to what taxes were paid. Under our law, taxes are payable both by the landlord, the freehold reversion, and by the lessee, meaning the person who have a lease on the property. With what taxes has been paid by them, I don't know. But whatever the tax that may have been paid, the reality is, in law, what you have is what you hold. And as of now, what they hold is the freehold, or what they held rather, because the acquisition has already taken place. What they held was the freehold reversion, whereas Eastern Nicholas holds the leasehold interest for another 70, possibly close to 90 years.
Okay. All right. All right. Well, thank you very, very much for coming in. I know we covered a lot of topics here this morning. We appreciate your versatility and your time.
Well, I try to do what I can. Thank you.
Definitely. Good job. Thank you for coming on the show.
Yeah.